Hey, good morning, everybody. Hey, good morning, Mike. How are you today?
Morning, Norm. I'm doing well. How are you, my man?
You know, hanging in there, living the geriatric dream. What else can I say?
Tell you what, man, it's gorgeous here in North Carolina. It's going to be in the 80s today, man.
Oof. So it's only April. 80s? Yeah.
Oh, man. So good. We'll get that swampy heat in the summer, don't worry. But right now is heaven on earth. And
take it while you can before the swamp arrives. So welcome back to Law and Legitimacy, everybody. You know, where the world is continuing to percolate along. Interesting, the Donald Trump trial is taking shape.
It's time for the percolator. It's time for the percolator.
No, Mike is not going psychotic. He's not suffering from depressive jumping bean syndrome, even though he's popping out of his skin with enthusiasm and excitement at the old wine being poured into new skins, which is how our country feels like these days, at least to me as I observe it. Trump trial, temperature rising, sort of, between Merchan and Trump. I'm not there. I haven't caught any of Logic's coverage of the trial. I don't know if anyone has. I wish it were being televised so that we could have an unmediated view of what's going on in the courtroom. I can tell you that from a trial participant's perspective, it is never the case that you see the reporting on a trial as corresponding to your own experience. And that's in part because your own experience is your own experience. And, the problem of solipsism is that we have minds, and the danger in the solipsistic approach is that we regard the world simply as what is reflected in our minds. Remember Rene Descartes' discourse on method.
Remember Descartes.
When he talked about how do we know that the world isn't merely a projection of some satanic prankster, and how do we know anything outside the content of our own experience as a matter of reason? And his answer, of course, is we don't. We have to do all that we really do know is that we think, and therefore the famous idiom, I think, therefore I am. Now that's taking rationalism a little bit too far. And I think almost all of us live in a world bounded by common sense where we accept sense perceptions and emotions emerging from within us as real and corresponding to reality. Any mature adult realizes that those perceptions and accounts of reality are not exclusive, and thus the purpose of dialogue is to arrive at joint understanding. That is a sense that two people can at least have a sense of correspondence between their mental states and observations in the world at large. And out of this grows relationships, out of this grows communities, out of this grows cultures, out of this grows civilizations. And so they can clash and conflict. And sometimes the result is violence. You see the conflicting cultures in the United States between the Arab world and Israel, and you see periodic violence because, quite frankly, two images of the world just can't occupy the same space. And so one force will force out the other. And, sometimes there is violence, and that's a scary part of history, but it's a constant part of history. More often, we accommodate change gradually, and we learn to navigate from one thing to another. And the promise of pluralism then is the ability to, I guess, recognize the multiverse, recognize that there are parallel possibilities of interpretation. A little too philosophical, perhaps, for this stream this morning. But with respect to Trump, and what's going on in the courtroom,
just to follow up, sorry, Norm, just to follow up on your press for having cameras in the courtroom. Good Logic he's done a video on his desire for that. He actually was denied a seat, even though he's got press credentials. He was denied a seat in the media gallery in the courthouse because they were filled to capacity. And this is a couple of days ago that he was reporting about this. And then also his Article 78 petition accompanying TRO have been denied as of yesterday. And he talked a little bit about that last night on his YouTube program. But we may want to have him on And just,
I would love to have him on. What did he say on the YouTube? I mean, what is he to win this needs a name behind it. What does that mean
yeah,
exactly?
I think that, we have a little more information than many, and I don't want to undermine, that sort of trust and confidant, status, but, um, I think that what he is saying is that he has been treated as though he is almost invisible by the court in that process, that, that the Southern District of New York, as an entity has just, prosecutors were very adversarial, self-righteous, and disrespectful to him. And the process overall made him feel, even though he's a practitioner, totally invisible. So we can get
Well,
more of that stuff
yeah, and
later.
that
That's what he meant
well,
by the name.
that is, I get that, and I mean, I know that Joe was struggling with whether to get involved at all because I think he wasn't sure that he wanted his name out there associated with that. And so memo to Joe: be careful what you wish for. It's a fight that you wanted to get involved in. You did get involved in it because if you didn't, you'd forever regret it. But you're almost better off not being the name, because once you become a name in the public eye, in effect, you lose control of a certain sense of your power if you let that happen. People will use your name on their behalf, to accomplish their own ends, and people will assume that you've endorsed that. You may not even know what they're doing. Hence the concept of a brand. If you get a big enough name, you become suddenly larger than life, but you can't be larger than the life you're living, and you have to pick and choose your fights carefully. So, would the case have benefited from an Alan Dershowitz in it? Let's say, I don't know. The prosecutors might not have been as dismissive, but I think the law was going to be the law. As to Trump in the courtroom, the Wall Street Journal reported a particularly odd exchange. I'm going to get it on my phone here and read it to you, between between the judge and Trump. Apparently, Trump was grumbling at a juror at some point. And Mershon, I can't find it, but Mershon told Trump's lawyer, I won't have your client intimidating witnesses in this courtroom. Please talk to him about it. And that tells you a little bit about the power dynamics in the courtroom. There he is, the picture on the screen, the glowering Donald Trump staring bullet holes through people. And he's a powerful person. He's got charisma. He's got tens of millions of people behind him. And I've never laid eyes on the man personally, nor shaken his hand. It would be interesting to see what sort of psychodynamic vibes he gives off. But clearly he is what we used to refer to in one of my former law offices as a transference lightning rod. People see him and they transfer from within themselves onto him all sorts of attributes that he may or may not share, all sorts of hopes and feelings that he may or may not possess himself, and they use him to reflect, to reflect back at others, what it is they want. In other words, you see Donald Trump, and is he going to vindicate your hopes for X, Y, or Z? You give him that power. You interpret his actions as consistent with your own. He may or may not even know he's doing that. I mean, think about the tens of millions of people who are voting for him. They haven't met him. They believe that he's acting in their interest. He may not even give two hoots about them. And so one of the things that is so fascinating about public life, and I've experienced just a little bit of this with the notoriety that I've acquired as a lawyer, is Robert Burns, the poet, once said, "Oh, would some gift the gifty give us to see ourselves as others see us." I can't remember the rest of the line, but "Oh, would some gift the gifty give us to see ourselves as others see us." I was on the phone yesterday with the wife of a person accused of narcotics dealing in a federal case here in New England, and we got to the point of quoting a price, and I asked who had the case before, and I said, "Well, that's an expensive lawyer. I'm more expensive." And they said, "How expensive?" And I gave them a number, and they said, "You're probably worth it." And I said, "Well, I hope so." They said, "You know how you're referred to in the tri-state area?" This would be New York, Connecticut, and others, on the streets. And I said, "No, as the monster." And I started laughing.
That's awesome.
I said, "Who refers to me as the monster? Seriously?" And the caller said, yeah, I said, I'm not a monster. I'm a decent guy. I mean, do you smell sulfur while we're talking right now? And the person said, well, no, but that's not a bad thing. When
I
you
was
go
gonna
into
say
court,
that is a high compliment, Norm.
yeah. So when you go into a courtroom, you really light it up. And I said, well, I have this constitutional problem. I believe in the United States Constitution. I believe in the individuals I represent. I believe that no person is the sum of their worst moments. I believe that a good fight in a courtroom respects the dignity of the defendant, no matter what he has done. And I've represented people who've done all sorts of things that are horrifying, and that horrify me. But I also know that in a discrete moment, a horrible decision can mark a life forever, but it's not the entirety of a life. And I think that one of the things that must go on behind prison walls is that people make a transition from a position of existential horror to one wherein they learn to form a community of regard for self and others behind a prison wall. And I don't know a lot about what goes on there. I haven't read much about it. Fortunately, I've never been to prison as anything other than a day-long guest with my clients. But I think that the comment that Mershon made about Trump is just so very, very revealing. And it suggests that his charisma, his larger-than-life persona, his role as a presidential candidate makes it almost impossible for him to step in a room and enjoy the presumption of innocence and enjoy equal protection of the law.
It really, and if Imperius were here, he'd be advocating for some sort of constitutional monarchy, right? And I think that at the outer limits of our justice system, Norm, the Trump effect is principally to illustrate, I think, this proposition, and it is that for the 99.99% of the American population, that the justice system is fit in terms of the idea that one can have an unbiased jury or a jury of their peers, if you will. Trump does not have peers, right? At the level that he exists and lives, there aren't 12 people out there, right, that are his peers in the manner that the justice system would require. Is it even possible or practical, we'll call it, for someone in Trump with, at Trump's level, right? He is, as you've already described, and as someone in the chat here, I think it may have been Mari, has stardust dripping off of him, right, wherever he goes. But is it possible for someone with such a reverberative impact on popular culture, right, for people who have never met him, never even seen him in person, to also have a fair trial
But here's the problem with what you've said, because if he is sui generis, that is unique, there is no one else like him, given his role as former president. Then he lives in impunity because he can't be judged by a jury of his peers, and that's clearly inconsistent with the rule.
Let me see if I can hold on. Let me mess with the mic settings real quick, Norm. All right, talk now.
When Mike does one of these, he's messing with the mic settings. Mike, mess with the mic settings.
Got him. I think we're good.
Well, I guess not. I hear a little bit of echo. In any case, the promise of equal protection of the law says that the law holds all people as equal. And so, here's the other thing, though, to think about, Mike. This is a stunning realization. But, if you're listening to this podcast and you're performing on this podcast as Mike and I are, you care about the law, you care about the news, you care about public affairs, and you demonstrate that by reading about it. You demonstrate that by talking about it. You demonstrate that by viewing things like this podcast. When you're picking jurors, especially in Connecticut, where we have individual sequestered voir dire, that is the ability to question jurors one at a time outside the presence of others, it is stunning to see how many people don't. So, I've had high-profile cases where, I assumed everybody was reading about my case. They didn't even know anything about it because they've got their own problems. Now, is it possible for a person even not following public affairs to not know who the president of the United States is? Probably not, because I do note that when psychiatrists are evaluating people in an emergency room to determine whether they're out and out psychotic, they want to ask whether they're oriented to space and time. and one of the questions they'll ask is, who's the current president of the United States? So that's a sort of baseline question that any competent person is expected to know. Then when you seek to try that person in a criminal court, the standard is not jurors who know nothing about the individuals in the case, because in the case of Donald Trump, it would be impossible to find probably a sane person who knows nothing about him. The question is, once knowing what you know about him, can you put his status aside and decide whether the state's allegations have been proven by a reasonable doubt? And that's the question in jury selection. There's a broad public misperception that jurors are to be totally ignorant of the players and the allegations. That's not the legal standard. Ignorance is not the standard. The standard is whether, knowing what you do know, you can be fair and impartial. And a line is drawn sometimes,
That's fair. Touche. And I think that you wouldn't be you if you didn't take that approach, because you talk about bounce religiously, right? And you talk about your approach to getting inside the mind of a juror and creating a relationship and humanizing yourself, right? Because you have a reputation that you often have to deal with in these cases that you're arguing on behalf of a defendant for, right?
And what's more, it's not just my experience. I mean, I've seen it in action. I've seen this is how judges make this decision. Some events are too far out there. If Trump had murdered someone before and a juror was aware of it, you're unlikely to have a juror say, "Oh, yeah, he's a murderer, but I can be fair and impartial on whether he, falsified some documents to cover up Stormy Daniels." I get that. So, I mean, I think, and I probably talked my way through this point. I think the takeaway, if you're watching this and you're watching jury selection and you're wondering how Donald's going to get a fair and impartial trial, the standard for selecting jurors is not ignorance. Ignorance may be bliss, but you're not going to have a blissful jury in this case. What you're going to get are jurors who can say, yes, I know he's the president. I've heard things about him. I understand that this is a case where the state of New York has to prove, or the people of New York have to prove, certain elements of an offense involving falsifying records. As a result of what I know about Mr. Trump, I can or cannot be fair and impartial in evaluating those claims. Another way of asking that question, if you're a lawyer, is, would you be predisposed to find him guilty because of everything you know about him? Do you have feelings about him? I might, in a voir dire, say, you get a dinner invitation. You get an invitation to go out to dinner with Donald Trump. How are you going to react? That's the sort of personal information you want from somebody. Oh, I'd love to have dinner with him. Well, maybe he's a partisan. I wouldn't eat dinner with that guy if I was starving. That's an anti-partisan. Yeah, I don't know. Is another answer. So,
I'm getting more and more interested in the concept of jury selection. The more that you and I talk about this stuff on stream, because my mind wanders a little bit. But in the case of, maybe a practical hypothetical here is asking a potential juror how they're likely to vote in November, right? If they first know that he is a candidate for president of the United States, and if they confirm that they know that, how are they likely to vote? Right. And if they appreciate that their vote on the court, right, that their decision as a juror, if seated, will have some consequence, some impact one way or the other on his ability to be elected come November, right? These things all seem inextricable to me, Norm, which is why it's not necessarily could they, just as a threshold issue. I think that my problem, or my reluctance to just immediately go to where you are, number one, is I lack the confidence and the experience to speak the way that you're speaking now. But I think number two, and more to the point, is just that why is this trial being rushed when this is an exception to the rule? Right? It's not every day that someone as magnanimous as Donald Trump is a criminal defendant in state court on charges.
Magnanimous, large-hearted. That's not a word I would use to describe him.
I absolutely would. I think that Trump is he's a benevolent guy. Seriously, I don't know that it's fair for us to be getting into sort of like a character analysis of Trump. Yeah, there are plenty of reasons.
All right, here's the challenge, peeps. Get us an interview with Donald Trump. It's time to talk. I want to make, I need a little FaceTime with this man to understand what.
Yeah, look, we've got over 1,600 subscribers now, so we're at his level.
Yeah, we're at.
All right, let's go. Let's move on.
We're not even tips on his coffee yet, So in any case, let's keep an eye on the Donald Trump trial and jury selection. It's a problematic thing.
Well, and there's, I think this is Yeah. Thank you to the chat. I'm seeing all these comments. Yeah. Right.
So Fischer was argued in the United States Supreme Court yesterday. According to press accounts, the argument seemed to favor the defendants, and the issue is as follows. Many of the J6 defendants, including Donald Trump, have been charged with counts arising under 18 United States Code 1512. That is an obstruction of an official proceeding count. This statute was amended after Enron to increase the penalty, or to place a penalty on individuals who obstruct or alter documents or intimidate witnesses in connection with an official proceeding. In another section, it says, or otherwise corruptly interferes with an official proceeding. Now, the defendants in the Proud Boys case and others took the position that the 1512 otherwise statute really didn't pertain to riots, that it pertained to evidence manipulation. And I was a little bit scornful of this argument when I first heard it in the Proud Boys case. It was raised by Nick Smith, who represented Fischer in the District Court of Appeals and whose certiorari petition was granted. And a law professor argued on behalf of Nick. So, I've said it before, I'll say it again. Good work, Nick. You spotted an issue that may be a winner, and you did a fantastic job of lawyering. My professional sense of rivalry with you makes it hard for me to acknowledge my pettiness in this, but I put it down publicly. You did a great job, Nick. And, the Supreme Court may have been persuaded. The argument would be that a statute that was designed to combat covering up documents, manipulating evidence, intimidating witnesses in the context of an official investigation is different than conduct, different in kind than conduct that was exhibited on Capitol grounds on January 6th. That is crossing a boundary from permitted to protected space, going into the building, looking around for congressmen, even though those congressmen were at that point engaged in an official proceeding, that is certifying the electoral votes. This statute is an imperfect fit, and it wasn't what Congress intended. It's an overbroad and vague application. I don't know, vague is really a First Amendment concept, but it's an overbroad application of this statute that is offensive to due process. That's the argument that was made more or less in the Supreme Court yesterday, that this statute is inapplicable to the J6 events.
Yeah, and lots of hay made over the word otherwise, right?
Mm-hmm.
And I think that, the Solicitor General argued that it's more of a classic catch-all as designed by the legislature or Congress. But I think Nick Smith was arguing that no, that is intended to be more of a dragnet. So in general, I think that the natural consequence of Nick Smith's theory of defense here and his argument is that facially that this law, this provision of 1512 is actually unconstitutional, that it does not bear the weight of constitutional scrutiny in the way it was actually designed. And now it's being applied in a way that actually just makes it quite evident that that is the case.
And and so let's say, and that is the argument, and it's a fascinating argument. I mean, language. When I saw at trial, when I first looked at the briefs on this, and I saw the word otherwise, I thought that otherwise meant otherwise. You can screw around with documents, you can intimidate a witness. If your purpose is doing so, if your intent is to do so with a corrupt purpose to influence an official proceeding, you're guilty. And then the transition to otherwise seemed to me to open the statute up to an almost infinite number of ways of corruptly influencing an official proceeding, including storming the Capitol. And that just didn't strike me as an implausible reading. Nick and others dug in on that, and in front of a different judge than the Proud Boys case, I think, I can't remember if it was Judge Nichols, they persuaded him in 3 cases that this statute was being misused. Jake Lang with Steve Metcalf, who's a colleague of mine, and defended Dominic Pizzola in the Proud Boys case. Metcalf took this up on appeal. Smith took it up on appeal, and there was a third case, and Nick argued them all and perfected the arguments, and then each of these individuals sought certiorari by the court. So let's say the court concludes that this was an overbroad application and strikes the 1512 counts. In other words, declares that they're null and void. Then each person who has been convicted will be entitled to resentencing. Those resentencings will, in some cases, be moot because they will have been sentenced to concurrent time on the 1512 statute and other statutes that cover the time. So 1512 carries a penalty of up to 20 years. Suppose you got 10 years on the 1512 count and then 10 years on an unrelated count, eliminating and with both sentences to run at the same time or concurrently. Eliminating the 1512 count really does nothing to your prospects because you've already got that time covered on another offense. Where the thing will be more troubling for defendants is where 1512 became the controlling sentence. In other words, where it dictates the total amount of time. Let's say they got 5 years on one count and 10 on the 1512 count. Eliminating the 1512 count will reduce the lawful sentence to 10 or to 5 rather. The more troubling cases will be people who pled and entered plea agreements under the shadow of a potential 1512 conviction. Because if you're a defense lawyer, your job in plea bargaining is to advise clients about, it's to make a recommendation about what they should do. Your responsibility is to assess the evidence, to assess what's admissible, what's not, to assess the weight of the evidence, how likely is the government to get this admitted, and if they do, how likely is a jury to be persuaded, and then to assess the likely consequences if there's a conviction. And so you go to your client and you say, look, I've looked at the file, I've done the analysis, and, in my view, there's an overwhelming likelihood you're going to be convicted if you go to trial. And in the 1512 count, the statutory maximum is 20 years. Now, the newspapers have really done a disservice to people by reporting the statutory maximum as the exposure for a crime. It is the exposure, but almost nobody gets the max. And so,
unless you're a proud boy.
Well, unless you're a proud boy. And so, it's a highly personal relationship between lawyer and client in the plea bargaining context. And your job is to make your best estimate, make your best recommendation, and then let the client decide. We in my office have tried any number of very difficult cases. And, people sometimes criticize me and my office for trying difficult cases. We don't wake up in the morning and say, hey, we're gonna try this impossible case just because we have big egos. Yeah, we have big egos. There's no question about that. But usually you try an impossible case because the client can't accept an offer. And that the state has made. So I once had the case of state of Connecticut versus Tony Moreno. There's a man who was accused of throwing his 7-month-old baby off the bridge, and there was compelling evidence that he did so. My job is not to be a moralist, say, he did it and therefore he should go to prison, because prison isn't about morals. It's about what the state can do to impose punishment on a person, what the state can do to protect society, what the state can do to rehabilitate a person. And, maybe there's a moral element tucked in there. But in the Moreno case, the state's offer was 50 years in prison, 50. There was no way we could accept that as a plea offer. And so we tried the case. There are other cases where great plea offers are made and clients reject them and they get horribly killed. The lawyer's job is to assess and advise. The client's job with respect to a plea is to decide. And sometimes you have situations where clients can't face the reality of what's coming, and they decide to try the case against the irrational hope that they'll be a recipient of a miracle. And in those cases, clients are sometimes crushed by the consequences. And as a criminal defense lawyer, it is overwhelmingly frustrating and crushing to experience that. But you have to remember that everybody at a trial has their role. The lawyer's job is to be as an advocate. The client's job is to accept the advocacy and make decisions. Or, as we sometimes humorously say, to put some distance between ourselves and the pain that bad decisions made by clients can cause. Is, we sometimes jokingly, not in a funny way, but in a dark way, say, You can lead a client to the courthouse, but you can't make them think. And, the chuckle there is a way of releasing a certain sense of despair that descends in response to the sometimes catastrophically bad decisions that clients can make. You have to remind yourself, you didn't put them on the other side of the V. They came to you having been accused of a crime, and your job is to save as much of their lives as you can, and to stand beside them and expressing the dignity of the human spirit, and the sense of integrity that every person, even the worst among us, is entitled to in our court system as a matter of law. So, the 1512, I mean, it's another side trip. I didn't expect to take off the 1512 case, but it's a real expression of what goes on in a law office. So the 1512 cases will undoubtedly be decided by the end of the term in June, and then there'll be a flurry of activity if it's decided in favor of the defendants, among those defendants who have already been convicted under that count or pled under the shadow of that count.
A trailing question here is, what this does to the timeline in Jack Smith's case against Trump in DC. And because obviously now that this is in the ether, right, these oral arguments are out there, and what I put on the screen is just interesting because Jamal Bowman is the congressman that pulled the fire alarm, if you remember that story.
I do. Yeah.
Several months back, and Justice Neil Gorsuch actually brought that anecdote up in examining the plain meaning of the statute.
Oh, wow. How did that go? Tell us about that.
Right. And I had a couple of other people in here mentioning that, but again, it's talking about the vagueness or the broadness of the term otherwise, right? Mm-hmm. And so trying to search for other examples, testing the outer limits of the state or the federal government's argument that this was an official proceeding within the meaning of 1512. And so Neil Gorsuch was using that example and others, right? Testing to see how far. And that's why I think the overwhelming consensus at this point is that the 9 on the bench are favoring Fischer, is because it became very obvious through some just light scrutiny, light application of sort of fact-based references in real life and things that are in the public consciousness, such as Jamal Bowman's pulling the fire alarm, that this isn't something that the government intends to use with any sort of regularity, right? Because there isn't an existing definition that would fit conduct, like physical conduct, that we saw on January 6th, that this was something else. Now, I will admit that in even saying that out loud, Norm, it does occur to me that even if the court finds in favor of Fischer, that this might not really hurt or harm Jack Smith's case against Trump that much, because Trump's conduct as recited is not physical in nature, right? It's not a physical intrusion or an argument of obstruction in the way that these other January 6th defendants have been charged. And so I wonder if there is some sort of definition that the federal government will rally around, even if they lose this case against Fischer at SCOTUS.
I think that's true. I don't see the impact on, I mean, I see some press saying this is going to be decisive in the Trump case. I don't see it. I think Smith will find a workaround, and it'll be his unique status as president, and that will cast a different light on this. But who knows? We'll find out. So those of you who are criminal,
did very little of what we promised, right, today. But who cares, right? We had a good time.
I mean, I hope we did. I mean, I went down some side roads because I think that it's one thing to read about a case in a newspaper and to read an interpretation by a non-participant of an event. It's another thing to hear about how the events look from a participant's perspective. And even if the participant, even if the person reporting, in this case me, isn't participating in the actual proceeding, there is an empathetic understanding of the role that Trump's lawyer played. And so I can imagine myself in his shoes based on the reports that I am reading, and I can imagine how I might respond to those issues. And so I think these discussions have some value to you listeners, because you're listening and watching because you're interested in how it works and how it all hangs together. And so what I'm trying to give you is a ground level perspective of how all this looks. As always, I could easily be wrong, and often am. But we're not promising you that will be correct here. What we are promising you is our honest responses, rather, to the issues of the day, and a discussion that you can participate in, and hopefully provoke wherever you go, so that we can talk our way back into a sense of sanity in the world. If you're a criminal defense lawyer in Michigan or in the Midwest near Michigan, mark July 17th on your calendar, because I'll be traveling to Grand Rapids that day for a keynote address to the Michigan Criminal Defense Lawyers Association. Flattered that they'll have me out. I talked to the event organizer the other day. I said, "Why me?" And they said, "Oh, your reputation precedes you." I'm like, "In Michigan?" So, I'm obviously deeply honored and moved. And we've agreed that I will talk for 90 minutes, and I will talk about the vocation of criminal defense lawyering, what it looks like from the ground level, what the ethical problems are, what some of the existential perils for practitioners are, and basically rally the troops to say that the defense function is valid and necessary, and ennoble people to continue on in what is often a very lonely and candidly sometimes soul-shattering experience. We're working a case in my office right now involving a home invasion and a vicious assault with a broomstick that reminds you of the Abner Louima case. And, just to immerse yourself in these facts hurts. And I think that lawyers need to find a way to discharge that pain. Sometimes it's through dark humor. Too often it's through substance abuse. In my case, it's through talking. We need, let nothing human be foreign to anyone. A great Latin poet once said, and I can't remember who it is. Nietzsche warned, don't look too long into the abyss, lest the abyss look into you. I think we look for spontaneous acts of, through our acts of courage, we become instruments of grace for another, and we sometimes need it ourselves. And so the address at the Criminal Defense Lawyers Association in Massachusetts will be a reminder of the human cost of defending, the human dignity of defending, the Christ-like character of a criminal defense lawyer, who Jesus once said, or maybe it was Paul, "The greater love hath no man than this, than that he lay his life down for a friend." A criminal defense lawyer's vocation is spiritual in nature, as is life. And so we will talk about the spirit of criminal defense in Michigan. If you're out that way on July 17th, come on out. I can't say it'll be a good time, but I'll have some fun.
Tombstone is one of my all-time favorite movies. And I don't think you've ever seen Tombstone, have you, Norm?
I don't watch a lot of TV and stuff, so I'm sorry.
It's a classic, mid to late 90s cinematic masterpiece.
Hmm.
And one of the, it's a fictionalized or sort of a, fictionalized account of the OK Corral. But in general, Doc Holliday is one of the main characters, and he's asked at one point in the movie why it is that he is so willing to fight for one Wyatt Earp, and why he is always there to sacrifice his personal interests in favor of Wyatt Earp. And he says, "Because Wyatt Earp is my friend." And the other gentleman says, "Well, hell, I got a lot of friends." And he looks at him sternly and says, "I don't."
All right.
So, it's a small community, Norm, but I'm glad that you're doing that. It seems like we've got several people here on the stream that are looking forward to you spending some time in Michigan. I guess this is the value prop from Janet: no tides, no sharks, and no salt. You got to spend longer than a day.
No, I'm going to be there a couple days. I think I get out there on the 18th, and they're putting me up for a couple nights. It's a good gig, first class flight, the hotel. I said it'd line me up with some stand up comedy somewhere, and so I'm looking forward to going. And candidly, I like speaking about this work, and I think it's important for people to understand that it's certainly good for me because it helps me to externalize all that I've absorbed in a punishing legal career with sometimes truly horrific cases. So come on out, see you there, and see you soon.
Yes, sir. So we will be back tomorrow morning, Thursday, April 18th at 8 a.m. Eastern time on X at LawPod Daily, here on YouTube at LawPod Daily, and over on Rumble. Over on Rumble, we've got a small thread going, courtesy of Jackson Barrett, regarding Orwell's 1984. and the creation of uniparty rule in the contemporary United States. And I just wanted to take the opportunity to remind all of you that Norm, way back when, did a reading and a selection on 1984 on the long form podcast. So maybe, Norm, we just need to research. We need to dust off some of that material and talk again about Orwell's 1984. And I think that within that, I also have some C.S. Lewis and the Screw Tape Letters that we can integrate together. I think those two play really well together in the modern moment.
I don't remember the 1984 episodes, The Perils of Being Old, but let's get them. Maury, good luck tonight. You're auditioning for a play out there, I think, in Northern California. I'd say break a leg, but my granddaughter did the other day, and the sight of her cast is horrific. So good luck. Let me leave it at that. All right.
All right. Well, we're out of here. I'm going to get on the road. Norm, enjoy your day. I love the vest. I think I need that. What is that?
Years ago, I represented a pipeline company that was a pipeline company that was trying to put a pipeline in the Long Island Sound, and so as always, I'm on the unpopular side, and it was called I don't know, Island East or something like that. So this was some of the swag I got together with the retainer, and I like the vest. So what are you going to do? You know,
got a comment yesterday from one of our regular viewers that they like this music better than the new stuff. And I'm here to tell you that I don't care. We're going to keep experimenting, but I am going to give it to you as we ride out just because I also like it. Norm, see you tomorrow, man.
AMF, yo.
AMF, yo. AMF.